Like a good neighbor, State Farm is there.
Let's go, dude.
Knowledge.
All week long. Order in the courts, all rise. The Honorable Creedence and Mikey, the legend in leather and lashes.
The trio that make you say, oh, good to see everybody. Sealand fans, perfectly placed for court.
Yes.
A lot of good stuff today. We're going to be bouncing around from place to place until we find a home. Creed, it's court time.
It is, and I'm going to introduce you to somebody that we're all. I'm basically committing abuse here for everybody. You'll see what I mean. A man named Gregory Johnson, who we are all going to absolutely hate here in the next few minutes.
Old Greg, looking forward to Greg.
Found this early this morning while I was just doing some eBay stuff, and already got a pretty good idea what's happening here. I just want to jump into this just to kind of not really to set the mood, but to just get things going today, and then we'll jump around a little bit. But like I said, you are going to absolutely hate Laura, not you. This man named Gregory.
Greg.
Bigfoot, you too. You're gonna hate. You're gonna hate Mr. Gregory Johnson.
Now his audio is connected. Mr. Johnson, can you hear me?
Yes.
All right.
God.
We are on the record then in the People of the State of Michigan versus Gregory Ernest Johnson. It's file number 21-20333-FH. Today's date set for a final conference in this matter. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Johnson this morning, Your Honor.
All right. And Ms. Underwood, where do we stand with the case?
Does he feel asleep?
At this time, Your Honor, I believe Mr. Johnson will be pleading guilty on a delayed plea basis, Your Honor, to the 4-year child support case, Your Honor, with the provisions that the sentencing be put out 11 months if Mr. Johnson gets his arrearage down to $8,000. It's my understanding he gets an attempt, and if Mr. Johnson manages to pay the whole arrearage down in that time, Your Honor, then he would be eligible for a misdemeanor disorderly in this case, Your Honor. I believe that is, and I believe Mr. Johnson is to pay $100 a month, Your Honor. I believe that is the plea bargain that Mr. Johnson will be pleading to today.
Okay. Ms. Brenner, is that a complete and accurate statement of the agreement?
That's correct, Your Honor. He's to pay a minimum of $100 a month. He did not pay last month, so I do expect him to make up that missed payment as well.
I did pay.
The front of the court system is not showing the payment at this time.
Has the
Mr. Johnson,
Miss Underwood has the receipt.
It's okay, Gregory.
We're not going to argue about this on the record right now.
Is Miss Underwood his mom?
I will send Ms. Brenner
the
proof I have.
Okay, that's fine. I just don't see it in the front of the court system yet.
Okay. Thank you, Mr. Johnson. But that is the plea you're taking this morning, correct?
Yes.
We can't see you anymore, Mr. Johnson. There you are.
There he is. Flush, I did one. I just missed.
All right, Mr. Johnson, will you raise your right hand, please?
Missed you too.
We can't even see his hands. How do we know what he's doing?
He might be doing something we don't want.
Can't see you now, so if you have your right hand raised, please let me know when you have it raised.
Yes, it's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I suppose.
I need a yes or a no.
Yes.
Yes.
You are Gregory Ernest Johnson, correct?
Yes.
Mr. Johnson, you heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, failing to pay child support?
Yes, I accept the plea.
Is it your intention to plead guilty today?
Yes, I accept the plea.
Are you satisfied with Ms. Underwood and the advice that she's given you?
I suppose.
The maximum penalty for this offense is up to 4 years in prison and or a $2,000 fine.
Yeah.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court, other than as we've discussed it on the record here this morning. Is that correct, Ms. Brenner?
That's correct, Your Honor.
I'm just so surprised
That's
he's
correct, Your Honor.
divorced. Ain't with
Is
the
that
baby
also
mama.
your understanding, Mr. Johnson?
Single
I
lady.
don't know. I didn't understand the question.
Other than as we've discussed on the record here today, no one has discussed a possible sentence with me. Do you agree with that?
With me, right? Okay.
No, with me. No one has discussed a sentence with me, other than as we've discussed on the record here today. Not Ms. Brenner, not Ms. Underwood, and not
I don't think
yourself.
so.
Is that right?
Right.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy. Mr. Johnson, if you're going to interrupt me, I'm going to hold you in contempt.
I'm sorry.
This is not a funny matter.
He's so far behind on
You have the right
child
to a
support, he'll
speedy
never
public
pay it off
trial
at
by jury.
$100 a
You
month.
can ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at trial, have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have to your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Johnson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yeah.
I suppose.
Do you also
Whatever.
understand that any appeal for the conviction
Rumble.
and sentence pursuant to this plea would be by application for leave to appeal and not by right?
I didn't understand that.
This guy's great.
Is he
You
slower?
understand that any appeal that you might
Oh, he's
make
a
from
dick.
this conviction and sentence
I suppose.
would have to be by application for leave to appeal and not by right.
Okay.
If you are not a citizen of the United States
least
of America,
8K.
conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
He's muted now.
I
I didn't mean to mute. I don't know how I muted.
Mayor.
How did I
We
mute?
hear,
Do you have any questions about any
We
of those
hear you.
rights, Mr. Johnson?
Crap.
You're unmuted now, Mr. Johnson.
I'm about to get, I'm not, I shouldn't be. I'm not on my headset though.
We can hear you.
Well, I'm trying.
We can hear you. We hear you.
Oh, okay. Well,
That works perfectly. You got the neck in there too.
Mr. Johnson, do you have any questions about any of the rights that I've explained to you? Do
no.
you understand that you're giving those rights up?
Yeah.
Go ahead and just give it up.
How do you wish to plead to the charge that on or about September 1st, 2018 through September 30, 2019, in the city of Adrian, County of Lenawee, that you did commit the offense of failing to pay child support?
I accept the plea.
If you want to plead guilty, you need to say guilty.
You want me to say guilty? Okay, fine.
If you want to plead guilty to this offense, then you need to say that you plead guilty.
I accept the plea. Okay, fine.
That's not,
Mr.
that's not a
Johnson,
guilty plea. So if that's all you're going to say, Mr. Johnson, then I'm going to continue your not guilty plea and we'll proceed to trial on January 25th.
I never entered a not guilty plea.
Yes, you
Mr.
did.
Johnson, there are two pleas available, guilty or not guilty. Which do you choose today? Guilty or not guilty?
They want the not guilty or the guilty, so that's fine.
No, Mr. Johnson, it's a matter of what you want to do.
Remember
today.
what the judge.
Do you want to plead
No,
guilty
it
or
doesn't
not
matter
guilty?
what I want to do.
Oh, profanity.
Mr. Johnson, are you going to plead guilty today or not?
Yes, that's acceptable.
If you want to plead guilty, you need to say that you're pleading guilty.
Yes.
Your audio was not clear. What did you just say?
Yes.
All right. This is the last time I'm going to explain this to you. And otherwise we're just going to leave the trial set. How do you wish to plead to the charge that you failed to pay child support?
Well, you determined that I was guilty, so yes.
Sir, the elements of the crime are you were ordered to pay child support and you failed to pay for whatever
My
reason.
income did not support that.
That
The
doesn't
judge
matter.
knows that.
That doesn't matter.
Well, he found me
Oh, look at
guilty,
his
so
attorney.
that's where
He
it
didn't
is.
find you guilty. He's
Yes, he
asking,
did.
were you ordered to pay child support and did you fail to pay it? It's either yes or no. If it's a yes,
did
then
not.
you plead
My
guilty.
income did not support the child support.
Judge, let's just leave it on for trial.
No, I want the deal.
Then you need to
Well,
admit what you did.
Mr. Johnson,
Mr.
you can't
Mr. Johnson,
Ms. Underwood,
you are,
please allow me,
Mr.
Ms. Underwood.
Johnson,
Maybe she should just let him say deal or no deal.
Mr. Johnson, you are
Yes.
confusing the issue. The judge found that the child support was appropriately set, okay? He
Which
found
it
you
was
could
not,
not
but
go
that's
back.
fine.
That is a
I
separate
get that.
issue
Okay.
than the criminal issue we have today. Now, did you pay that child support or not? If you did not, then you need to say
I
the
was
word
unable.
guilty.
No, I did not. Okay.
So is that a guilty?
Judge is about done with him.
We're not going further with this. The record is already not satisfactory.
I'm guilty of the circumstances that set this thing.
Mr. Johnson, please do not interrupt me. If you interrupt me again, I'm going to hold you in contempt and I'm going to give you 30 days in the Lenawee County Jail. All right. I do not believe that the record created in this case today to this point would appropriately allow me to accept a guilty plea. Mr. Johnson has not indicated.
Yes, guilty.
Justice.
Mr. Johnson has not indicated a clear intent to plead guilty and admit to the facts that would support a guilty plea in this case. Trial is scheduled for January 25th at 9 a.m. If I don't already have proposed voir dire questions and jury instructions, I'd like those submitted
Don't even sit up.
by Friday.
Yes, Your Honor.
And we will proceed to trial on
Too late.
January 25th. There is a plea agreement deadline on January 23rd. So assuming that Ms. Brenner is willing to leave that agreement open, I will accept a plea up until that point. If Mr. Johnson decides that he wants to unequivocally admit his guilt.
Guilty. I plead guilty.
Too late.
I've made my decision for today. If
I
Ms.
plead
Underwood,
guilty.
Ms.
Do you want
Underwood,
to
and
set a
Mr.
time for January 23rd, Judge,
Now you won't even stop saying
that we can
guilty.
check back in or
Yeah, no, I
not?
can't stop. Oh, he's
I
realized.
plead guilty today.
See, he realizes what's going on.
Mr. Johnson, I've already explained to you that you have behaved today in a way that I am not going to accept a guilty plea from you based on what you've said on the record here today.
I don't,
If
because I
you
just
decide
found
that you want to make a guilty plea, I would ask you to contact Ms. Underwood, have her arrange a time either tomorrow, Friday, or Monday to enter that plea. And if you show up and you answer the questions,
Do it.
Mr. Johnson, I've said it. This
Let's
is the last
do
time I'm
it.
saying it for you. If you interrupt me
Let's
one
do
more
it.
time, I'm going to hold you in contempt and sentence you to 30 days in the Lenawee County Jail. I am done. I've instructed you now as to how you can proceed if you want to enter a guilty plea. Contact Ms. Underwood. She'll make arrangements with my office. This hearing is concluded. Please log out.
Love it. Well, there you go.
This is so out of date.
Judge neck
615
brace,
for the,
Creed.
drug education fee. Okay.
Holding it down at the old double
How
dirty.
much was the?
sorry.
Two and
Oh no, I was
five.
just saying he's holding it down at the double dirty. I need an update on that guy, Creed.
Yeah, I
That's,
got to
a
do some
lot
digging.
of
Like I
fines
said, I
and
found that
fees.
this morning, and I was like, oh my God.
Mr. Nagia, are you working right now?
As of right now, no.
Um,
Is he got like he got rear-ended and he's got like a lawsuit coming up, or?
Do you understand that as a result of this felony conviction today, you'll not be allowed to own or possess any firearms or ammunition?
Yes, sir.
You'll also be required to provide a DNA sample as
Judge
well as
Whitflash.
hand and fingerprints as a result of your felony conviction. Do you understand that?
Yes, sir.
I believe that these are all priorable offenses. So if in the future you're charged with any drug-related, theft-related, or DUI-related crimes, your sentence could be increased by virtue of your punishment today. Do you understand that? You're nodding your head, yes, but my court report actually has to write down what you said. Yes. The other thing about the DUI is that in California, driving under the influence is considered to be an inherently dangerous offense.
Judge
So if
slip
you
and fell
do
on
so,
all
and
these.
as a result, cause the death of a human being, do you understand you could be charged with murder?
Yes, sir.
Murder.
Murder, you say?
So while you are on probation, Mr. Nagia, you're going to be ordered to obey all laws, but also all rules of your probation officer and any orders of any court. You'll be required to report in person to probation at 801 11th Street between the 1st and 15th of the month, unless otherwise directed, in any event within 7 days of your release from custody. You'll be required to report any contact that you have with law enforcement to your probation officer within 24 hours. While you're on probation, you'll not be allowed to leave the county for more than 48 hours without permission from your probation officer. You'll also require their permission prior to moving out of the county. If you change your address at all, you must supply that change of address to your probation officer within 24 hours. You'll be required to submit your person, vehicle, residence, and also any property under your control to search and seizure.
Bonsai.
If
4 months.
if ordered by your probation officer, you'll be directed to participate and complete any general counseling.
Slightly.
You'll not be allowed to have any firearms or ammunition, and you'll be ordered to pay any applicable fees and costs as agreed upon with your probation officer, and also depending upon your ability to pay those costs.
Lisa.
And that will be in addition to the jail time we discussed. I think it was 1 year in each case concurrent to each other. Do you understand those terms of your probation?
Yes, sir.
Mr. Nagia, if you're not a citizen of the United States, you need to be aware that your conviction today will result in deportation. exclusion from admission to the United States, or denial of naturalized citizenship. Do you understand that?
Yes, sir.
Also, if you're on probation
Come on,
or if
thank
you're
you.
on parole for any other criminal case, your convictions today constitute violations which could result in their revocation and imposition of sentence. Do you understand that?
Yes, sir.
Mr. Hogan, did you want to state factual bases for these, please?
Your Honor, I'm going to start in case 679. Your Honor, if this case were to proceed to preliminary hearing, the people would show that on September 7th, 2022, in the city of Modesto, County of Stanislaus, in the course of a lawful traffic stop or traffic contact, the defendant was determined to be the driver of a moving vehicle. In the course of that contact with officers of the Modesto Police Department, based on the training and experience of those officers, the defendant was determined to be under the influence of a narcotic substance that, based on his consuming of that narcotic, made it so the defendant was under the influence and unable to drive in a manner that would have him be in control of the vehicle with the expected safety of a normal person. The people incorporate, well, sorry, let me take a step back. For the purposes of that plea, the narcotic drug is identified as fentanyl, which is an opiate. For count one, in the course of the contact with officers and the subsequent search of the vehicle, officers located both a controlled substance, to wit fentanyl, as well as an operable loaded firearm.
Yikes.
The people, for the purposes of count one, which designates fentanyl as a controlled substance, would be able to prove in the course of a preliminary hearing that fentanyl is an analog of heroin, in that the consuming of fentanyl has an effect on the user which is comparable or greater than the effect that is expected from the consuming of heroin. The people also incorporate all facts as necessary for the purposes of this plea found in Modesto Police Department report number MP 22.
It's called the double dirty panel.
8285.
Famous around these.
And as to case ending 679, Mr. Reed, do you stipulate to that factual basis?
It's all stipulated for the limited purposes of the plea.
It is. We ain't been here in a while.
And then as to case ending 487.
Your Honor, if this case were to proceed to preliminary hearing, the people would show that on October 31st, 2022, in the city of Modesto, County of Stanislaus, the defendant was identified as one of two people that broke into a vehicle located in the city of Modesto. In the course of stealing from that vehicle, the defendant took items from, including tools, a computer, and an iPad, that the value of those items would be in excess of $950. The estimated value by the owner of those stolen items was approximately $1,850.
I get the monies for the Fetty
The
somehow.
vehicle was locked at the time of the break-in, and the defendant did not have permission either to enter the vehicle or to take any items from the victim. The people further incorporate all facts as necessary for this plea contained in Modesto Police Department case number MP 22022726.
Mr. Reed?
For limited purposes of the plea, so stipulated.
Thank you, sir. All right, Mr. Nagia, have you had enough time to talk to your attorney today?
Yes.
Have you told him everything you know about your case?
Yes.
And then other than what we have stated here in open court, has anyone made any different promises to you today?
No.
Has anyone threatened you today in order to enter your plea?
No.
And are you currently under the influence of any drugs or alcohol?
No.
Before I take your plea, do you have any questions for me?
No.
Counsel, have you had enough time to advise your client?
Yes, Your Honor.
Have you advised him of his rights, defenses, and the consequences of his pleas?
Yes, Your Honor.
And are you satisfied he understands each of these?
Yes.
Start with case ending 679. Charged as follows. We're about September 7th. Violation section 1137.
Did his mic go out?
California Health and Safety Code.
Yeah, I'm not sure what happened there. He's just reading instructions to the dude. While he does that very quickly, I want to show you college. See this blonde sitting over here just to make me laugh? I'm going to show you later. It looks, I spit an image of what my ex Tara looked like. I mean, like pretty spot on from here anyways, on the screen, and that's making
To
me laugh.
plea in that I will still find you guilty.
I'll show you later. See.
Yes.
He was all high on fentanyl, and I would imagine, did he get in an accident or just get pulled over with all the stolen goods in his car?
See, I was really confused. I don't know if the judge was trying to teach him a lesson. Like, look, you could have murdered somebody driving around high.
Yeah, I'm not sure where that came from. If it was murder was the case that they gave him, or
well, let's just jump over to yours because
funny.
I feel like we're pretty much done with this guy.
All right, yeah, I get it.
He's going to jail.
This plea that it is knowingly, voluntarily, and intelligently entered. I'll accept it.
See
and
what
find
Tara
him
did.
guilty of this offense. Mr. File, anything else on sentencing?
Nothing further at this time, Your Honor.
Well
Ms.
over.
Ernest,
I just
you're
pointed it
muted.
out. Jesus Christ, you guys.
Thank you, Your Honor. We ask that the court follow the recommendation and waive the fines and fees under Ramirez.
Very good. Is there anything you'd like to say, Ms. Johnson, before I sentence you? I
That's
didn't.
gonna be loud. Creed, would you?
Okay, thank you. I'll follow the recommendation, 7 days in jail credit for time served, 357 suspended for 24 months, $5,000 fine, all of it suspended for 24 months. Conditions of the suspended fine in jail: have no criminal law violations on any act committed after imposition of sentence today, and do not drive without a valid license and insurance. We'll send over this paperwork for you. Is this the only matter you're being held on?
No.
Oh, okay. Well, we'll send over this paperwork for you, but this case is done. Thank you.
Joseph Jones, Your Honor.
Beautifully announced today.
You say Justin or Joseph?
Joseph.
Thank you very much. Okay. You are Joseph Clay Jones, is that correct?
Clay.
Yes, Your Honor.
Mr. Jones, we're here on two cases. One's a
All right.
driving under the influence DWLS 3 and ignition interlock violation. The other one is a driving while suspended 2, hit and run attended, and ignition interlock violation. We're here for a pretrial on each of them. We have a March 7th readiness hearing and a March 20th jury trial. So I'm going to hear from the defense first. Any issues to raise at pretrial?
No, Your Honor, we're asking that the dates leave set.
Very good. Any issues from the prosecution?
Mine was just a Tuesday weekend.
No. Okay, we'll next see you on March 7th for your readiness hearing. Mr. Jones, thank you for appearing today.
But I worked.
Yes, Your Honor.
Good.
Frank Martinez, Your Honor.
Thank you.
No, and it's an absolute miracle that it's happened once.
You are Frank Allen Martinez Jr., is that correct?
Yes.
Mr. Martinez, the court's found probable cause to hold you to answer to a charge of theft in the 3rd degree, a gross misdemeanor.
Hey, beautiful hair.
364 days in jail and a $5,000 fine plus assessments.
I did.
you hear me go over rights a little bit earlier, or would you like me
With
to
his
go
new
over
video
the laws?
setup and new audio setup, you couldn't hear him.
Very good. You have the right to be represented by an attorney of your own choosing, and if you cannot afford one, an attorney will be appointed at no expense to you. You're presumed innocent unless the prosecutor proves the charge beyond a reasonable doubt. You have a right to a speedy trial, which is 60 days from today's arraignment if you're held in custody on this case, or 180 days from the readiness hearing that I'm going to set if you're not held in custody on this case. You have the right to a jury trial. You have the right to hear and question the prosecutor's witness. You have the right to testify on your own behalf,
Worth the wait.
call your own witnesses, to compel witnesses to appear at no expense to you. You have a right to remain silent, and that right, exercise that right can't be used against you at all. You have a right to disqualify up to one judge if you do so in a timely manner. If you're found guilty at a trial, you'll have the right to appeal, but in that case, you'd have to file a notice of appeal in a timely manner. You plead guilty, you give up all of these rights. If you're not a citizen, you've got a right to consult with an immigration attorney. And the reason is that a criminal conviction for a non-citizen could result in deportation, exclusion from admission, or denial of naturalization under the laws of the United States. Now, would you like me to appoint an attorney to represent you in this case?
Yes.
I'm going to appoint the Grim Lawyer to represent you. I need you to fill out an attorney application. It's only a single page. We're going to enter not guilty plea on your behalf. I believe, counsel, that he's going to be seen later today on a couple of Class B felonies and a misdemeanor in Superior Court. Does that look right?
Yes, that does look right.
Okay, what's the city asking?
Busy
for on
kid.
bail?
At this point, Your Honor, the city will defer to the court on bail. I don't see any other criminal history other than pending charges.
Okay, Mr. Martinez, I'm gonna release you on your own recognizance on this case, or on the following conditions. Appear for a pretrial March 21st at 1 p.m. via Zoom, appear for a readiness hearing March 16th at 2 p.m. via Zoom, appear for a jury trial June 2nd at 9 a.m. in person. Have no criminal law violations, report any change of address to the court clerk from your attorney. Get that attorney application filled out.
That's a good enough
filed.
excuse, Rick.
Meet with your
I'll
attorney
take
before your pretrial. If you're held in custody on those felonies, your attorney will be up to see you. And if you do get out, don't go within 1,000 foot of 405 Pacific County. Also,
Whoa.
send over
Stop
this
the clock.
paperwork for you. Thank you.
Your Honor, the second date was May 16th, right?
And smell is
May
sweat.
16th.
Okay, fine, thank you.
Okay, that's it. Thank you. What do we have next?
Bo
Beautiful.
Radic, Your Honor.
Beautiful hair. Foofy. He had a great look, but very hard to get away with. If you're
You are Bo
somebody
Jacob
identifies you.
Radic, is that correct?
Yes, Your Honor.
Mr. Radic, we're here for a pre-trial on your charges
Oh,
of
you know
driving while
anybody named
suspended,
Bo
third,
is
ignition
trouble.
interlock violation and failure to transfer title.
Always.
Looks like we have a readiness set for March 7th and a jury trial set for March
My birthday.
4th. I'm going to hear from the defense. Any issues to raise at pre-trial?
Thank you, Your Honor. I believe that Mr. Radic is pleading to some Superior Court charges later today, and so we can keep the date set, but we will likely resolve long before
Very
the
good.
readiness.
Can I just plea to it today?
No, not today, because we don't have the guilty plea form filled out, but they could put it on as soon as tomorrow.
I do.
I'll come. I'll come see you today or tomorrow.
Oh,
and
if
we'll
you
get it
did,
on the
they
docket
haven't
this week.
given it to me, but we can put it on quick.
Okay.
Any issues from the prosecution?
No objection.
Okay,
Miss Grimm out of
as soon
nowhere.
as they get the matter before, I'll see you again on this case, okay?
Thank you, Your Honor.
Thank you, Mr. Radic.
We haven't seen Miss Grimm in a while.
Mark Schaff, Your Honor.
Thank you.
Just letting you know, we are live and licking as well with the great
Okay,
Judge
any chance
Stansberry.
If we want to jump to there, more than welcome. If he's
Let's see what this guy's got to offer first.
all right.
Okay, counsel, we need to talk for a second while we got, you are Mark Douglas Bridges Schaff, is that correct?
Yes,
Oh,
Your
what
Honor.
a name.
Okay, my understanding, Mr. File, and I've done some research on the law, did you both get my email?
Yes, and I did have a chance to review that statute briefly this morning.
Let me tell you what my view of it is so far, as I found no case law on it, but it does seem to be similar to enhancements that are used in both misdemeanors and felonies. And I'll take the example of driving under the influence. The issue of whether we had a refusal, what the BAC was, are factual issues.
10, count 'em.
And
10
if
memberships
both parties
gifted,
agree, then
Sean, you're
has
awesome.
to
Thank
go
you.
with that
The Wexler
determination,
strikes again.
and we do that all the time. The issue of whether I have someone under 16 in a person's vehicle seems to me that it has to be something that's alleged by the prosecution and either found by a jury or a judge at a trial or admitted by the defense before it can be used. That's my initial indication. Do you agree with that, Mr. File?
Yes, Your Honor. I believe that if the fact is not established before the court, that the court cannot make a finding that that is the case. So there would be a fact that has to be proven and alleged.
Similar to a BAC or a
Yes.
no
Or
test.
even the existence of a passenger would have to be proven and alleged and proven.
Okay, and so in this case, the defendant is pleading guilty to the driving under the influence, but the city is not alleging and the defendant is not admitting for the purposes of the sentencing enhancement that we have minors in the vehicle under 16. Is that correct, Mr. File?
Was he, you think he's on a date?
Ms. Grimm and I did not actively discuss that last week before filling out the forms. However, we have had an exchange this morning a little bit, and it is the city's position that yes, there were 2 passengers under the age of 16 and 1 over the age of 16 in the vehicle. And I've made Ms. Grimm aware of that. I don't know if I doubt she's had a chance to communicate with Mr. Schaff about that.
Okay. And without that communication, I don't think we can go forward with the guilty plea. Ms. Grimm, what do you think, Ms. Grimm?
I think that's up to Mr. Schaff, but obviously he's unaware of the circumstances as a result of that. I don't know if the court would be open to, because with as much time as he's got in, I don't think the enhancement, unless the court's going to go much higher than what he's already served. If we put it over to tomorrow, for example.
Is his name Shaft, Mr. Shaft?
So
I'm willing to speak to him about it and put it on the record.
okay, either that or I can explain it to him briefly how it's going to impact what we're doing today.
Okay, let me go ahead and do it. Give me just 1 second. Okay, how do you pronounce your last name, by the way?
Schaff.
Schaff?
Schaff.
Schaff?
Schaff.
Schaff.
I mean, it could be
Schaff.
family.
Okay.
I mean, it could
Mr.
be.
Schaff, you're charged with driving under the influence, first offense within 7 years with a refusal. The city is alleging that there were 2 persons in the vehicle that were under the age of 16. And if that is the case,
There's some
you're
great news. Thank you,
admitting to
Kay.
that as part of your guilty
There you
plea,
go. Good stuff.
there are some enhancements. I have to add an additional 24 hours in jail for each one of the minors, the minimum
Soft.
mandatory, along with the minimum mandatory 48 hours in jail. And I'm required to impose a $1,000 fine in addition to the fines that are required under law, and that's required also for each one of the minors. Of course, if you're indigent and I find you indigent, the fines don't make a difference. Where it makes a difference is that if you're admitting that there were 2 persons under the age of 16, your minimum mandatory sentence is not 48 hours in jail. It is 96 hours in jail. Do you understand that?
Yes.
And do you wish to continue with your guilty plea?
Yeah.
You sure?
Ms. Grimm?
Ms. Grimm.
It's up to you. I know this is a change. This was something that we were made aware of over the weekend, so I haven't had time to come up and talk to you. There is an additional requirement for a longer interlock device requirement under the statute as well.
I do miss when
I mean,
they ask, like, you know,
it's still
where
up
you
to the
work
judge
here,
as to
what
whether
you
or not he
make.
follows
Oh,
that
yeah.
recommendation and follows the mandatory
The old Knox
minimums.
County
But you've been in
class.
jail for 14 days. The judge has to impose no less than 4 days. So it's your call, buddy. I can't make the decision
your
for you.
call,
If you want to talk
pal.
to me some more about it,
Dude.
we'll have to put this over to tomorrow and I'll come see you.
Your problem.
Yes,
You
And
figure it
as
out.
Ms. Grimm said, the change here is that I have to impose a minimum mandatory 4 days in jail. I can't.
Yeah. Yeah, that's fine.
Okay.
I'll wait.
Okay.
Ms.
Okay.
Grimm?
In the cause number that ends in 640, I have a statement of defendant upon plea of guilty to a charge of driving under the influence, first offense within 7 years with a refusal and with an allegation and an admission that we have 2 persons in the car that are under the age of 16. Have you had a chance to review this guilty plea form with your attorney?
What's
No.
I think so, on his hand here?
I came and saw you. We went over it. That's the document we went over the other Friday. You,
Okay.
you called me and we went
Your
through.
Honor, I've been.
Huh?
I would like to just interject. I've been observing Mr. Schaff. It appears that he might have some questions that he would like to address with Ms. Grimm.
It appears he might be a little slow.
Based on his conduct.
I'm sorry. We're gonna have to wait until tomorrow. Sorry that it's not that way, but we'll come back tomorrow. Ms. Grimm. Okay.
Be kind, rewind.
And I want to amend that guilty plea form. So we've got that allegation of the 2 minors under 16, the same way that we've got the admission of the denial. We just don't address it very often. So we'll come back tomorrow, Mr.
He
Schaff.
quickly just said, yeah, we'll
Okay.
do that tomorrow. No time today. I like that.
Joseph, Your Honor.
We'll catch up with you tomorrow, bud. Don't worry.
All right, so Mr. DeBoard, these petty theft cases, which actually, by the way, it's no longer called petty theft now. They just passed a new bill and they renamed it misdemeanor theft. So anyway,
Eddie,
I find these a little challenging for these circumstances. I mean, you took 2 sandwiches. It's not like you went in there and you robbed them blind. But at the same time, you have, more priors for this type of thing than I can even, recount. So there has to be some sort of consequence. I'm not going to make it horrible, but I'm going to go ahead and impose a 5-day jail term. I'll give you credit for the 2 that you've already done, which means you got 3 more to do, and then you're going to get out. I'm not going to put you on probation. Although I'll fine you $150 in imposed court costs, I'll waive the fine. So you just owe the cost. So you owe me 3 days in the court cost, and then this matter's over, and then go forth and sin no more. All right?
Okay.
All right. You may go with the officer. Thank you.
He stole 2 sandwiches.
Andrew Dickinson. Are you Mr. Dickinson, sir?
Yes, sir.
Mr. Dickinson, do you understand your rights in court today?
Yes, sir.
Did you receive a copy of the complaint that was filed against you?
Yes, sir.
Did you read that? Do you understand what it is that you've been charged with?
Yes.
You've been charged with domestic violence. Specifically, it's alleged that on or about February the 13th of this year within the city of Heath in Lincoln County, Ohio, that you did knowingly cause or attempt to cause physical harm to a family or household member. That's a first-degree misdemeanor, carries up to 180 days jail, up to a $1,000 fine. How do you wish to plead?
Not guilty.
And your current address?
1722 Watson Road, Heath, Ohio.
Toy Mom, enjoy your day at work.
And do you have any other place you can stay?
I could stay with my mother if I need to.
All righty. Are you employed?
Yes, sir.
Where do you work?
Clean Harbors in Hebron.
What's it called?
Clean Harbors in Hebron.
And what do you do for them?
Clean Harbors.
I'm a warehouseman.
How long do you work there?
About 7 months now, sir.
And do you work directly for the company or through a staffing service?
For the company, sir.
All right. Let me take a quick look here at the file, and then I'm going to give you an opportunity to make a statement if you want before we set bond. All right?
While he does that,
Okay,
let me
see
remind
what the
everybody.
Officers had to write about this.
Go ahead and like the video. We do as little talking as we can, but I know sometimes it happens because we love to talk to everybody. We like to see what everybody's got to say. But Licking County, if you've never been to Licking, oh, what you've been missing. Yeah, he has some sandwiches. Too many sandwiches. He stole sandwiches. Go ahead, punch on in. Do what you gotta do. Sin no more. Yes, it's a sin to steal. He fell asleep last night. There's some lulls like this right here where we'll get our talking in. But this guy accused of a little domestic abuse. Oh, you're cuddling with the cats. Cat cuddling.
Where were you arrested? At the apartment?
Yes, sir. I went back to my home. We've been living together the whole time.
Are you a veteran?
Yes, sir.
What branch?
United States Marine Corps, sir.
And what years were you in the Corps?
2011 to 2015.
And what was your MOS in the Corps?
0631, radio operator.
All right. Any deployments?
Twice.
And where were you deployed?
Okinawa, sir.
Okay. Were you honorably discharged?
Yes, sir.
He does got that look loud. All right, all right, all right.
All right.
Yeah, you work with old.
All right. Based on what I see here in the court file, your lack of any significant criminal record, and the input from the prosecutor's office, I'm going to go ahead and release you on your own recognizance on the condition that you have no violent contact with Mrs. Dickinson. So I'm not prohibiting any contact, but if things get out of hand again and the cops get called out, even if they don't file charges, your bond can get revoked, in which case if you're unable to post the new bond, you'd be sitting at the jail until this case got resolved. So make sure that you follow that rule. Now, the case is going to be randomly assigned to one of the judges in our court, set for a trial. Until and unless an attorney gets involved on your behalf, notices are going to go directly to you. So make sure your address is complete and correct, including the apartment on your bond paperwork. If you're going to hire counsel, start making those arrangements as soon as you get out. If you're going to go court appointed, get an application at the jail. But since you're being released, it'll be your job to get it turned in. They won't do that for you. Understand?
Yes, sir.
Thank you.
And the key, Mr. Dickinson, is to not wait until the day of your trial. I think it's, if the Marines say Semper Fi, which is always faithful.
Toy Mom.
I think it's the Boy
Yes.
Scouts who say always be prepared. So
Another
be prepared. Don't dilly-dally on this. Do you have any questions?
No, sir.
Very well. You may go with the officer. Thank you, Mr. Dickinson.
Thank you, sir.
Nicholas Ditto.
Always looking to punch somebody in the face.
Hello, sir.
Good afternoon, Mr. Ditto. You understand your rights today?
Chad
Yes, I do.
Kruger.
All right. Did you get a
Good call.
copy of the complaint?
Yes, I did.
Did you read it? Did you understand what it is you've been charged with?
His last name is
Yes,
Ditto.
Looks like you've been cited for
Ditto.
theft. It's a first-degree misdemeanor. They're claiming this happened on the 19th in the city of Newark.
Yeah.
It's commonly now known as misdemeanor theft, and it carries maximum penalties of up to 180 days jail, up to a $1,000 fine. How do you want to plead?
Well, I asked the lady for the pop, right? And then the cops came and then they asked me to leave, and I told them I wasn't on Speedway property. So I told them, no, I'm not going to leave. And they were like, well, we're going to make you leave regardless. And they went in there and talked to her and basically convinced her to say that I committed theft. So I guess I'll plead no contest.
Well, if you plead no contest, you're not
great
admitting that you're
explanation.
guilty, but you are admitting that what they say happened is true.
For the most part, yeah. Sorry.
And this is what it says. Ms. Ann stated that she did observe Mr. Ditto consume some of the fountain drink that he did not purchase while at the counter. So what that means is I would find you guilty because that's taking something without permission. Do you understand that?
Yeah, but I did it. I said I bought the hot dog, and then I took it. I absentmindedly took some swigs of the pop to wash down the hot dog.
Well, if you don't think that you did anything that merits conviction, then you need to enter a plea of not guilty.
Just washing it down, bro.
It's not theft, I guess, in his eyes.
Because I'm telling you, if you plead no contest based on the facts that are in here, which you are agreeing with as being true, which I just explained to you, those facts are sufficient to sustain the charge if they're true. A no contest plea is you saying, yeah, they're true. You saying no, they're not true is a not guilty plea, and it's a trial, and the jury.
Very dry hot dog.
I'll plead not guilty, I
Okay,
guess.
let's do that. What's your address, Mr.
Gas
Ditto?
station hot dog. I need a break.
7783 Kendall Road. Is it all right if I change my plea at court without an attorney?
You decide later you want to change your plea to guilty or no contest as long as the court accepts it. You don't have to have a lawyer there. Yes, you can change your plea at your next court date, all right?
Okay.
Now, do you use the Kendall Road address as a mailing address?
Hey,
One of those all
Okay,
shriveled
who
up,
actually
you
lives
know?
there?
Had some
My
veins
parents.
happening.
And
Oh,
do they allow
just
you to
that.
get mail sent there?
Yes, they do. They notify me.
I was going to say, and they'll tell you as well.
Yeah.
No, it's just his hair right here. You mean, Gary? That's just a little lock of beautiful lock of.
Well, don't forget, you can check your case online at our website. You can always check in with the clerk's office as well. But we will be sending it the notice by mail until and unless a lawyer gets involved. All right.
I think.
Okay. I'll check online today when I get it, if I get out.
Well, I'm going to let you out. Is there anything else that's going to keep you in there?
I'm doing golfing guns
No.
already.
All right. Well, you'll be released on your own recognizance on the condition that you not return to any Speedway location at all. So it's not just the one up there at Church and 21st.
Hello,
No
RLS.
Speedway, okay?
Glad you're
Speedway.
here.
So you can't go in any Speedways. Understand?
Okay. All right. I understand, sir.
All right. So as I said, we'll get this randomly assigned, set for a trial. You'll get notice by mail. Any questions?
No, thank you.
You may go with the officer.
So
Thank
we
you,
had
Mr.
the
Ditto.
guy before, 2 sandwiches he stole.
All right.
This
Next we
guy's
have Melissa Dreyer.
stealing soda.
Yeah.
Maybe he's about
Good afternoon. Is it Dreyer or Dreyer?
It's Dreyer, Your
Dreyer.
Honor.
So you are Miss Melissa Dreyer.
Yes, Your Honor.
Did you understand your rights in court today based upon the information in the video presentation?
Yes, Your Honor.
Did you understand that information?
Yes, Your Honor.
Did you receive copies of the 2 complaints that were filed against you?
Yes, Your Honor.
Have you had an opportunity to review those? And did you understand what it is you've been charged with?
They already had a
Yes,
little
Your Honor.
couple there.
Looks like both of
He said he
these,
wasn't
well,
paying for it.
it says 1 of 2. Oh, here we go.
And
All right. So these are both alleged to have occurred on Sunday in the village of Hebron. Excuse me. The first count alleges that you knowingly caused or attempted to cause physical harm to a family or household member. That's commonly known as domestic violence. It's a first-degree misdemeanor. Carries up to 180 days jail, up to $1,000 fine. Second count alleges that you recklessly by means of force resisted or interfered with your own arrest. That's known as resisting arrest. It's a second-degree misdemeanor, and it carries maximum penalties of up to 90 days in jail and up to a $750 fine. So how do you wish to plead to the charges?
Not guilty, Your Honor.
Miss Dreyer putting her hands on another. I find that hard to believe.
Hey, Slim Jims are like $5 now. We're getting up there.
And what is your address?
1167 Lake Forest Drive, Hebron 43025.
Say hi. Get up. Hi.
Oh.
Are you employed?
Yes, Your Honor.
Where do you work?
I work at DFAS, DOD.
And how long have you worked there?
A year now.
And what do you do there?
I'm an accountant, Your Honor.
Wow. An accountant, Green. At eVest.
Are you a veteran as well?
Yes, Your Honor.
And what branch did you serve?
Army. Your
And what was
Honor.
your MOS?
92 Yankee Logistics, Your Honor.
And how long were you in?
8 years, Your Honor.
Yeah.
And were you honorably discharged?
No, Your Honor. Or I was honorably discharged.
Okay.
Yes.
So you enjoy full benefits, VA benefits?
Yes, Your Honor.
All right, good. All right, let me see something.
He worries about our veterans. I love it that he keeps an eye on those kinds of things. Very important to him.
He does, and he does ask questions to kind of verify, if you will, I believe. Reasoning for doing that.
Oh, this absolutely would have to be a low point in my life.
And an accountant.
Yeah.
Not supposed to be starting tomorrow or anything like that.
Okay. Let me
Actual
take a
job.
quick look here at the file, and then we are going to address your bond, okay?
Yes, Your Honor.
Full benefits means she gets to go and shop on base. She still gets to get cheap into amusement parks. She can go stay at Shades of Green at Disney World. And if you go to the right places, she can still get her military discount at Speedway on soda. Why would you say that, bud? Why is she doing her face like that?
Oh, it looks weird, though.
That is so weird. Don't do that. She got TMJ. She's like grabbing her jowl.
Oh, Gary.
All right. Is Mr. Miranda appointed on your other cases?
Yes, sir. I tried to get a hold of him, but I could not get a hold of him. Couldn't get a hold of him.
Well, if you want him to be appointed to this case, you're going to have to fill out a new application, okay?
Yes, Your Honor.
Is Mr. Napier a veteran as well?
Yes, Your Honor.
Jack Napier?
He also.
Did you guys meet in the service?
No, Your Honor. We met through DFAS.
Okay. All right. Well, I'm going to give you an opportunity to make a statement before I set bond here, but let me caution you. We are recording everything. Anything you say could possibly be used against you, so it's not wise to talk about what may or may not have happened on Sunday. So other than that, is there anything else you want to say before I set your bond?
No, Your Honor.
Smart move.
Dick Harris, ladies and gentlemen.
Okay, so when I was over here goofing around, what I was doing is I was looking at what else is going on, and what else is unfortunately going on is 2 pending violation of protection order cases and another domestic violence, none of which have been resolved. So on this bond, I'm going to set it at $5,000 cash surety or 10%, but it's going to have 2 very important conditions. Number 1, you're not to consume any alcohol or illegal drugs while the bond is in place, and even more importantly, you're not to have any contact either directly, indirectly, through third parties by way of
Not much
social media
longer.
postings with Brian Napier. Now, if you still have belongings that you need to retrieve from the Lake Forest Drive address, you're going to need to contact the Hebron Police Department for what's called standby assistance. They will meet you there, allow you to retrieve your belongings without having any problems with your bond. we'll get this set. There's no guarantee that it gets assigned to me, but I think at least 2 of your other cases are pending in front of me. And I'm not sure what our next court dates are on that. When's the last time you talked to Mr. Miranda?
Last week, I believe.
All right, we'll stay in close contact with him because obviously it's his job to look out for your interests. You need to make his job as easy as possible by staying in touch. If you're unable to post the bond, the jail will send your application for counsel down here. If you are able to post the bond, don't violate any of the terms, because if you do, your bond gets revoked and you end up
so you know,
higher bond. So
you don't see
we'll get this randomly assigned and set for a trial, and unless Mr. Miranda or any other attorney gets involved, we'll send those notices directly to you. Don't put the Lake Forest Drive address on your application or your bond, okay?
She loves hard, everybody.
Do you have any other questions today, Mr. Dreyer?
Yes, sir. So you said $5,000 with a 10% down?
I did make it a 10% bond. Yeah, cash surety or 10%. Any other questions?
No, sir.
You may go with the officer. Thank you, Ms. Dreyer.
Thank you.
She got that.
Sarah Forgrave.
Sarah.
Good afternoon. Are you Ms. Forgrave?
Yes.
All right. So, Ms. Forgrave, a couple of matters we need to address. You pled guilty to the charge of falsification in my courtroom back on December the 15th of last year. I imposed a 7-day jail term, ordered that you report on Wednesday, January the 25th of the year 2023 at 11 a.m. You failed to appear on that day, so a warrant went out for your arrest, and I put on what's called a show cause order for you to show cause why I shouldn't hold you in contempt of court. The warrant that went out for your underlying case provides that no bond will be set, that you're simply to be taken to the jail to serve your term. Do you understand that?
Yes.
Now, the other thing that we have to do is we have to address this contempt. And even though I have ordered you to show cause why you shouldn't be held in contempt, that's misleading. Because contempt in many ways is much like a traditional criminal charge, although there's a few small differences.
Hit
So
like
the
sacks
big
or
things
like
are,
punch her in the
the
face?
allegation is that by failing to report that you are in indirect
Hit her.
contempt of my order to show up that day to serve your jail term. The penalties for contempt are up to 30 days in jail, up to a $250 fine. However, the burden of proving that you are in contempt of the order is on the state. You have all the same rights that you would in a traditional trial. And, you could confront your accusers, subpoena your own witnesses. You would have the right to present a defense to the contempt allegation. You wouldn't have to because it's not your burden. And you would have a right, in fact, not to testify.
Hell yeah,
I wouldn't
Gary,
hold
get
that
it.
against you if you didn't.
Get some.
Also, importantly, under those circumstances, you have the right to be represented by an attorney. And if you couldn't afford one, we would give you one at absolutely no cost to you if you qualified, which you very likely would since you're incarcerated at this time. So I'm going to put on an order that basically carries your previous sentence into effect. And so you got picked up on, looks like on Saturday.
Correct.
So you'll get credit towards those 7 days from the time you got arrested, all right?
Okay.
7 days for lying.
We're also going to address the contempt because basically you can either admit, which is like, yeah, I'm guilty of being a contempt of your order, judge. That means the state doesn't have to prove anything. You waive your right to a trial, which, by the way, can be with the judge, but not with the jury. You give up all those other rights. I'd simply decide what the appropriate punishment should be for the contemptuous actions. As I said, it could be up to 30 days, up to a $250 fine. You also have the right to deny being in contempt. That's like pleading guilty, in which case we'll put all those things in place. And if you want to get a lawyer, you can get one. So do you wish to admit to being in contempt of the court's order, or do you wish to deny that?
Yeah, I mean, not denying. I'm not denying it. Sorry.
You're going to deny it. What's your current address?
8005.
Just said I'm not denying
State Route
it, and he said
22.
you're denying.
Yeah,
Northeast
yeah.
Roseville, Ohio.
I didn't
All right,
understand
that's the
that.
address you gave me at some point back in the day. I didn't date it. Normally I do that.
And I think you might have heard me wrong. I'm not denying it.
You're not denying it. You're going to admit to it?
Yeah.
Okay.
Correct. Sorry, sir.
That's okay.
Very bad.
You have the right
wording.
to counsel, and you have the right to be represented by court-appointed counsel if you qualified. Was it your intention to give up your right to a lawyer?
Yeah.
All right. And Sue, we'll need to do a waiver on that as well. You understand that what other rights should be given up based upon my earlier explanation?
Yeah, definitely.
Yes.
You understand the maximum possible penalties I can impose upon you?
Correct.
Has anybody threatened you in any way or promised you anything to get you to do what you're doing here today?
No, sir.
Are you under the influence of any alcohol, drugs, or medication right now?
No,
Gary
sir.
and
Take-
Stan here.
Lastly, I just need to verify, are you a citizen of the United States of America?
Yes, sir.
All right. All right. I'm going to have the officer down there, Sue, go over your attorney
Sue.
waiver form with you. I'm going to take a look here real quick. I'll give you a chance to make a statement about why you failed to appear, okay?
I can't.
Okay, thank you, sir.
I'm a rough rider.
Sue, come on in.
Wasn't that a band, Mikey? Do you remember?
Was not was? Yes. Yes, it was a band. Was not was. They had a hit.
Pop rock group founded in '79. Walk the Dinosaur.
Walk the Dinosaur. Yeah.
That's right. Wish we could see Sue. Before we wrap things up today, I want to show you how Judge Middleton's morning started. It is kind of funny.
Oh, there she is, everybody.
There she is.
The crowd goes wild.
I hope she had a great day off.
Thank you, Sue. Ms. Forgrave, did you review that form before you signed it and understand what it said?
Yeah.
All right. So, as I said, I'll give you an opportunity to make a statement if you like, although you don't have to, but I'm kind of curious why you didn't show up and what all happened.
I mean, my father's house burned down. He's in ICU right now. And honestly, even if I had made it back in town, I probably wouldn't have turned myself in. I mean, he's not in the best condition. So I was worried about coming and, you know.
Well, that's a pretty legit reason to want to ask for a continuance. But you forgot the most important part, which was to notify the court of what had happened. Then I could have given it some reasonable consideration. As of right now, I have to be perfectly honest with you. I'm skeptical. All right.
Right.
Yeah, I mean, can't you call the court to give them that excuse and say, is there anything that we can do?
I'm a creature of habit, which means I tend to use the same phrases and inform people the same way most times. I'm fairly certain if we go back and look at the recording of your change of plea hearing, I would have been very clear about what would happen if you failed to report for your jail term, right?
Yep, you were very clear.
It was an active rock station, Angela. You kind of heavier side of the rock and the roll.
The ruckus and the ruckus. Classic.
I gotta know. Were you just saying was not was, or was that a reference to the group?
So there's basically two forces at work here. One is there's never a good or a convenient time to go to jail, and I recognize that. And, you know, in some ways it's more challenging having issues in municipal court than common pleas because a lot of the folks who come to our court actually have some semblances of normal lives, such as jobs and responsibilities, car payments, things of that nature that they'll lose if they have to go to jail over. A lot of folks that are facing felony charges really don't have those same concerns. So I'm more than happy to try to accommodate folks so that they can minimize the impact that the incarceration will have on them. That's the one side of things. The other side of things is if I don't, impose any type of consequence for just blowing off a court date, nobody's ever going to show up for a court dates, right?
Right.
So I have no choice but to give you the 30 days, and it'll be consec to the underlying offense. I won't impose any additional fine, but I'll order that you pay whatever court costs apply to just the contempt proceedings. So do you have any questions today?
Great to see you.
Nope. Thank you, sir.
All right. Well, thank you. And if in fact your father's house did burn down, I hope he had insurance and I hope he's safe.
Thank you very much.
You have a good day.
Nice to you. So
You
I
too.
guess.
All right, Mr. Hadley.
He wasn't too bad on her.
All right. Next up, we have Scott Hunley. Are you Mr. Hunley, sir?
No, but I think it could have been.
All right. Mr. Hunley, you understand your rights in court today?
Question.
Yes, I did, sir.
We have several matters that we need to address.
Uh-oh.
I looked at this 2017 case and thought, boy, that's an old one. Then I looked behind it and I looked at the 2011 case. And that's even older.
2011?
So let's back everything up. You do understand your rights, correct?
Yes, I do, sir.
All right. Let's jump in the Wayback Machine with Mr. Peabody here for a minute. We're going to go back to August the 2nd of 2011 at approximately 11:25 p.m. It's alleged that you were operating a blue 99 Ford Ranger on National Road near Conley Avenue here in the city of Newark, and God forbid you were the passenger and you didn't have your seatbelt on.
No, yes, sir. Yep.
That'll cost you up to $20 if you were to be convicted or plead guilty. How do you want to plead?
I'll plead guilty on that, sir.
All righty.
It's a pass.
You understand you don't have to do that, right?
Yeah, I know. Yeah, yep.
You presume to be innocent. State has the burden of proof. You have a right to a
Going
trial, but
crazy
all
up in
that's
there.
gone if you plead guilty. Understand?
Yep.
All righty.
With finance charges, though,
And are you a
that's
citizen of the United States?
$1,800 now.
Yes, I am, sir.
All right. Well, at long last, our national nightmare is over. I'll go ahead and impose a $20 fine in order to pay court costs on that matter. All right?
All right.
All right. Now let's go to the 2017 case, which, as I said, I thought was going to be the
National
old one, but
nightmare.
it's not. And this time it's alleged that you up your ante and got yourself a seatbelt ticket, but this time you're alleged to have been the driver, which means
Yes, I got rid of my car. I got no car, still bicycle.
All right. So that
Trouble.
one, because they're saying you were the driver that time, that's a maximum $30 fine.
Nice stuff.
How do you want to
Yes,
plead
I
to
know,
this
sir.
one?
Guilty.
All right. All those same questions apply. All the answers yours that you gave me still apply as well.
Yes.
All righty.
I'm going to a bicycle. It's a lot easier.
Okay, but don't forget you can get an OVI on a bicycle too.
Yeah, I know, sir. I know.
I've heard you can even get one on a motorized bar stool.
Yes, you can. Yep. I might go to walking. I don't know. It's better for you.
That's true.
Yep.
Very true.
Not one, but
Very
two.
true.
All right, $30 in court costs on that one. Then the last one, you're in luck because it's assigned to me. You've been charged back in May of 2021 with driving while under a license forfeiture. It's a, let me verify. I think it's an unclassified misdemeanor, but let me double check.
Yeah, I don't even know.
Is. So there's no jail time associated with that charge either. And because it was assigned to me, you can do one of two things. You can stand on your plea of not guilty, in which case I'll set a bond today. We'll come back and have a trial, or you can just change your plea to guilty or no contest and wrap this one up too.
If I plead guilty, do I get out today? So I got a couple things I got to,
Well, here's the deal. I cannot put you in jail if you were to plead guilty or be convicted of this charge. Okay. If you stand on your plea of not guilty, I'll set a bond for you. Now, typically that would be an OR bond on an unclassified misdemeanor. But if you have a history of not appearing for court, like say since, I don't know, 2011 or maybe 2017.
I ain't seen you in years. I ain't seen you in years, 10 years.
I know, but normally that's a good thing. But when you were supposed to see me and you didn't, that's a bad thing, right?
So we was in the process of moving on the last one. I remember that. That's about all I remember.
All right. Well, how do you want to? You want to stick with your not guilty, or do you want to just switch it over and get it over and done with?
Man, I'm trying to go home today. I'm not one to want to be in jail.
Well, let me verify that you don't have anything else holding you in jail other than this stuff.
Seems like a great guy.
I don't think you do. So just listen to me one last time. If you were to plead guilty or no contest and I were to enter a guilty finding, the court does not have the authority to order that you be held in jail or that you serve any jail term. Do you understand?
Oh, I plead guilty then, sir. I plead guilty. I plead guilty. I plead guilty.
All right.
I plead guilty. I did it.
Do all the questions that I asked you from the 2011 case, do all those answers still apply?
Hey, everybody laughing at me. Sorry about that. I didn't know what you meant.
That's quite all right. It was kind of fun getting there.
Yeah, it was.
All right.
This guy.
So here's what we're going to do on this one. $150 in court costs, but no jail, no probation, no nothing of that stuff. So you're finished with all these cases now. See?
Can I ask you a question?
Well, I don't know. Ask yourself, wait 3 seconds and ask yourself whether it's a good idea to ask me whatever it is you want to ask me.
Okay, never mind then.
All
I'll
right.
wait.
You have a good day, Mr. Hunley. You may go to the office.
Yeah.
Wow. You said you had something you want to show us from Middleton this morning.
Yeah. So listen, just so you guys know, just filmed in front of a live studio audience. This is the beginning of his day to day, and we'll just watch a few minutes of it and see how his day started. It's kind of, we got to be, his audio's off a bit here.
We are here. Got back last night. Our new video system is hooked up. I can't figure it out. There's sawdust all over everything. They put some monitor right in my way. All the equipment isn't here that we need. It was supposed to integrate the JAVS cameras with Zoom cameras. Maybe I still don't know what I'm doing. No one's here yet. The tech people aren't here yet. Judge Patterson's not here. And so it's always a little hectic to get back from a trip.
Sawdust
But
everywhere.
I'm back. I had a wonderful, wonderful trip. Key West is a wonderful place to visit in February. I met Brian and Amy and did a tribute of our own to Tom Corcoran. Jimmy Buffett was in town just before we got there. I guess it was quite a week. A couple of public concerts, a couple of private concerts. And yes, I turned it on and I could hardly hear it. So somebody said your microphone sucks. So I think that may be true. So we got a lot of problems.
He's back and
but
it
as I
sounds
said, no one's
exactly the
here yet.
same.
I called Texan as I got here. They're not here. Judge Patterson's not here, and I have a very busy morning.
YouTube.
We have arraignments, pre-exam conferences, sentences, show cause hearings, and then sobriety court this afternoon. So it's good to get back to work.
Judge
Anyway, it
Middleton
was
is
a very
a
nice
parrot
trip.
head.
With some very old friends from since we were 12 years old. We do this every year at President's Day weekend. All right, some people can hear it, some people can't. And we are working the bugs out. But anyway, thank you to all of you and welcome back. It is good to be back to work.
So he does that every morning when he fires things up. He who's he talking to? He's talking to YouTube. He's the only one that I know of that does this. Before it's his first thing that he does in the morning. He fires it up and he just kind of rambles off about what happened the day before or whatever. I was telling you guys, this is kind of a follow-up to, I was telling you, his really good friend that had died. Remember I told you about who was a big Jimmy Buffett fan and everything. But I knew he was heading out. But I just thought that was funny. Sawdust everywhere. There's got this great big monitor that's right in my way in front of him. That would be annoying.
Hey, I like that they put in new equipment, though. That means they're staying invested in Zoom Court, which is good for us. That's true. We'll have more content to share with everybody. So that's
he's
a
great.
plus.
He's great to watch. Things go at a pretty slow pace for the most part. But he is just he's a normal dude. It's fun. He'll keep things live a lot too. So you can hear a lot of banter, and it's a small town. He knows everybody, but Middleton's definitely one of my favorites. And yeah, right. I do love that.
I love
he
him.
really
Good.
likes being on YouTube. I mean, if that's the first thing that you do is fire up your stream and say hi to everybody, talk to yourself basically, and just tell he's always got a story or something to tell. Straight up in the morning, and it's usually pretty early too. It's the 8 to 8:30 range that he does that. But anyways, I think that they're getting ready to remodel actually the entire
Think so?
courtroom, if I'm not mistaken. But we'll see.
But
yeah, I think that in the morning he keeps it on until they go. I think that his first thing when he fires it up, he keeps it going for a little bit, but. Anyways,
there's times I think all of them should cut the chat off because some of them are just ridiculous. Just
it is, yeah, and it's unmoderated, and it's lots of sex bots and lots of very opinionated people that doesn't listen. As unfortunately, as human beings, we can't be trusted. You know, and I think that the chat has a lot to do with some people that have gone away and gone off of YouTube, and that's a shame. But,
yeah, I think could be a reason we don't even have one of our favorites anymore. But
yeah.
Good afternoon. I'm District Judge Herman Marable from 67th District Court here in Flint.
I really do miss him yelling at people and such.
I miss the dirty desk, clutter.
Oh my God. And then what's her name there in the right in his courtroom?
Oh yeah,
him, attitude,
just
yelling,
laying it back on him as hard as he gives it. She gives it back twice as hard.
Bigfoot, Golf and Guns, Carol, Gary, Sean, Wexler, Toy Mom, Golf and Guns times. Thank you guys so much. Yeah, I definitely miss Judge Marable. Marable. Say it right, would you?
Marble.
Marble.
Don't forget, we have a case-only channel called We Got a Case on YouTube. That is all case stuff that you'll see there. Here and there, we'll try and do some exclusive stuff for that. But eventually, one day, that's where you'll see all of our case being handled over there. Is this a good-looking woman? I couldn't tell. Hold on, let me see. Couldn't see for the picture. Thought we had a redhead in the house.
No.
She could be hideous. I was looking at a very small picture with these glasses on.
Show us, Stansbury. Come on.
He's leaned back. He's letting her know that he's the boss around here.
If you want, you can waive your right to counsel and simply change your plea to guilt or no contest and wrap this one up today. Up to you.
I would like to plead guilty.
Okay.
Never mind.
False alarm, as they say.
That's what they call seeing things from a distance. We love you guys. Until the next one, stay whatever you want to be. Safe. She was not attractive at all.
Not at all. She might be from Nye County.
You got to look at her in a 1-inch